Hello everyone. While the previous presentation was about the capacity to sue, this presentation focuses on the capacity to be sued for a tort. A suit cannot be brought against the defendant when the act is an act of state or when the tort is committed by the crown, a foreign sovereign, an ambassador, a public official, a minor, a lunatic, or by a trade union. An act of the state is an act done in exercise of sovereign power in relation to another state or subjects of another state. State here is used in the international law sense, that is, a nation state. Supposing A and B countries are at war with each other and A bombs B's territory, causing injury to persons and property. Action for the injury cannot be initiated in municipal courts because they are sovereign acts. Here, the acts are done by the public officials or representatives of the state with the prior approval of the state, or they may be subsequently ratified by the state. Acts of state are applicable only to foreign nationals and not against citizens of the country. Citizens of the country are governed by the law of the land. In India, the principles of English law are followed in this regard. Regarding the liability of the crown for the tort, the fundamental principle of English law in the beginning was that the king can do no wrong and hence no action could be brought against him. The Crown Proceedings Act did away with this privilege, and therefore the position now is that the Crown is liable for all wrongful acts of its servants in the same way as any other individual. But the Act does not authorize proceedings in torts against the Crown in his private capacity. Similarly, where the Crown acts under the power or authority vested in him by a prerogative of the Crown or by a statute, he cannot be sued for a tort. In India, under Article 361 of the Constitution, the President and the Governors of State enjoy personal immunity and they cannot be proceeded against in any court for exercising their powers or for performing their duties. Under Article 300 of the Constitution, the Union of India and the states are legal persons and can sue and be sued as any other individual. The extent of liability of the state shall be the same as was the liability of the Secretary of State for India representing East India Company under Section 65 of the Government of India Act 1858 and would be subject to the provisions made under any Act of Parliament or any state legislature in exercise of powers conferred by the Constitution. Under the Government of India Act 1858, the East India Company was not liable for torts committed by its servants while discharging sovereign functions, that is, anything done in exercise of sovereign powers. No law has been made so far by either the Parliament or any state legislature in this regard, and hence the principle of state immunity is extended to a limited extent in India. Therefore, barring functions such as administration of justice, maintenance of law and order, and repression of crime, which are primary and inalienable functions of constitutional government, that is, functions that cannot be outsourced to private parties, the state, that is the central government or the state government, cannot claim any immunity from liability for the torts committed by its servants in discharge of their duties. Coming to foreign sovereigns, under English law, no suit can be filed against an independent foreign sovereign or a sovereign state unless they voluntarily submit to the jurisdiction of the courts. So far as India is concerned, no suit can be brought in a court of law against any foreign sovereign unless permission is obtained from the Government of India under Section 86 of the Civil Procedure Code. The rule is also extended to foreign corporations owned by foreign states. Under Diplomatic Privileges Act 1964, in England, no suit can be brought against an ambassador, high commissioner, or any other diplomatic envoy without prior permission from the government. This act gives effect to the Vienna Convention on Diplomatic Relations 1961. The position is the same in India also, and before filing a suit against a diplomatic agent, the permission of the central government has to be obtained. so far as public officials are concerned. Where public officials act in exercise of sovereign powers conferred on them by the state, they cannot be sued in their representative capacity for the torts committed by them or their subordinates. The relationship between the public official and his subordinate is not that of a master and servant. They are both representatives or servants of the state. But if they cause injury to others in their personal capacity, they can be sued, and the defense of sovereign authority will not be available to them. Now, coming to minority, minority is not a defense in an action for tort. He can be made liable for torts like trespass, where mental element is not required to constitute a tort. But where intention or negligence is required, minority may be a defense based on the nature and circumstances of the case. In India, a person below 18 years of age is a minor, and he is not liable for breach of contract because he is not competent to enter into a contract. But where an act is both a tort and a breach of contract, he will be liable for tort even if he cannot be liable for breach of contract if the tort is independent of a contract. But where the tort is so connected with the breach of contract that it is part of the same transaction, no suit for tort can be brought against him. Where A hires a horse from B for riding and B warns A against making the horse jump hurdles, and A makes the horse jump hurdles during which the horse is injured and becomes useless, though here A has committed unlawful use of the horse, he cannot be sued for tort or breach of contract because they are part of the same transaction. But where A hires a horse for riding and subsequently sells it wrongfully to C, here the tort of conversion is independent of the breach of contract, and hence A can be sued for conversion. Regarding trade unions, under the English law, the Trade Disputes Act 1906 provides that no suit can be filed against a trade union or its members or employees for torts committed by the trade union. The act was amended in 1927 and trade unions were made liable for strikes. Thus, a trade union can sue and be sued in its registered name. In India, under the Trade Union Act 1926, a trade union may be registered or unregistered. When registered, a suit can be filed against it in its registered name. When unregistered, a representative suit against one or more of the members can be filed. According to Section 18 of the Act, no suit can be filed against the members of trade union in respect of trade disputes. Regarding lunacy and drunkenness, they are not defenses in tort, and hence a lunatic or a drunken person can be sued for torts like trespass, assault, etc. However, when mental element is required to constitute a tort, a lunatic cannot be sued for such tort. In the case of a drunken person, only when he was intoxicated without his knowledge or against his will and made to commit a tort, he cannot be sued for tort. This in brief is about the rules relating to capacity to sue and the capacity to be sued in torts. Thank you.